I am Mr. Chair, the presiding chair for today's hearing. Today we're here to hear a appeal of removal order in the case of People of Canada, specifically the Ministry of Public Safety and Emergency Preparedness versus Agnes Moju Kimbemni, which is called appellant. The appellant is challenging the removal order which was issued against him under subsection 63(3) of the Immigration and Refugee Protection Act. From now on, we call it the Act. In January 2015, a member of Immigration Division from Immigration and Refugee Board of Canada determined that he is inadmissible on the grounds of serious criminality. Paragraph 36(1)(a) of the Act states that a permanent resident in Canada who has been convicted of an offense under criminal code that is punishable by a maximum term of imprisonment of at least 10 years is admissible. The appellant acknowledged that he committed the offense under criminal code punishable by a maximum term of imprisonment term of at least 10 years. However, he is arguing that pursuant to the paragraph of 67(1)(c) of the Act, there is sufficient humanitarian and compassionate grounds to maintain his permanent residence in Canada. The appellant's burden of proof is the balance of the probability. Is the appellant counsel ready?
Yes, Your Honor.
Is the minister's counsel ready?
Yes, Mr. Chairman.
Okay. Appellant counsel, you may proceed.
Thank you. Good afternoon, Mr. Chair. My name is Hassan. I am teaming up with my co-counselor Pam to defend our beloved client, Mr. Mohammad. Mr. Chair, this is a case of lost innocence as a child who didn't have close ties with his family as they divorced after 1 year arriving to Canada. My client, Mr. Mojo, was 9 years old when he arrived to Canada with his family. He was lonely, socially imbalanced, and had no close family ties at all. He lost his childhood at once and started his adulthood being unprepared to deal with the outside jungle we are living in. He met a group of friends that didn't guide him in the right way and ended up having a youth record that is not proud of. Mr. Chair, our client is aware of the bad situation and determined more than ever to turn around and be a model of peaceful, productive society member if he is given a second chance. And for God's sake, who doesn't need a second chance in this anti-human world? Thank you. Our client is in the right path and he knows the value of education and having the proper set of skills to succeed and make it happen and be economically independent to excel in his life for many years to come. In February 2013, our client was convicted of a harassment offense under the criminal code. His spouse withdrew her complaint later. He was 19 years old back then and she was 26. He lacks the social skills to be kind to his spouse as he witnessed firsthand trauma of his family split when he was 10 years old. It is anticipated that Mr. Majhu will say he will not commit any further crime anymore because he's aware that such act will deprive him to stay in Canada as becoming inadmissible person as per paragraph 36 of Immigration and Refugee Act, IRBA. Today we shall hear from 3 defense witnesses, Mr. Majhu, his father, and his brother. We anticipate that our client will admit having a criminal record, but this is not the end of the story. He is in the right path to have a good, prosperous life, full of hope and good future. Our client appreciates the value of education and he is pursuing his studies to achieve the independence and being treated like a normal human being. Our second witness is Mr. Majhu's father, who shall share with us his opinion and thoughts and tell us the exact root causes behind Majhu's previous unsafe and odd behavior. Also, Majju's father will inform us about the medical condition of Majju after having a major medical surgery which happened a few months ago, and the need to be closely under medical monitoring by his doctors due to his alarming medical conditions that his home country, Congo, will not provide in case he was removed from Canada. Our last witness is Mr. Majju's brother, who shall testify that why his brother has lived a bad childhood and how the unpleasant experience unfolded into bad social behavior that he cannot control alone. Also, his brother shall testify about the current situation of Congo, which is, by the way, a war zone by all means, and the need upon Canada to provide safe shelter and protection under human and compassionate grounds consideration. Thank you, Mr. Chair.
So the counsel for the minister, you may proceed with the opening statement.
Thank you, Mr. Chair. My opposition counsel. Mr. Chair, today's case is very straightforward. By the end of this trial, you will learn that the appellant, Mr. Ignace Mojo Kimbambi, who is standing here today, in fact, he's sitting, does not deserve in any manner to be a member of our society. Not once, not twice, not 3 times, Mr. Chair. You will learn today that in numerous counts of crimes that he committed and has been convicted in a very short period of time of his life. In fact, he chose a very serious criminal pathway for his career, and yet he does not realize that his criminal acts neither have a place in our society nor can be called a petty crime. Mr. Chair, my name is Mohammad, and here is my co-counsel, Ms. Nan Leng. Together, we are the counsel for the Minister of Public Safety and Emergency Preparedness. We are here today to persuade the Honorable Tribunal that removal order of Mr. Ignace is fully justified and a much needed decision for the safety of our citizens, our society, and its members. Mr. Chair, Mr. Ignace is a citizen of Congo. He arrived in Canada in 2002 as a dependent of his father. As a nurse in Congo, his father immigrated to Canada in the skilled worker class. His parents separated after a year later. The divorce was finalized in 2005. Worried about his behavioral problem and his learning problems at his school, in 2006, his mother referred him to the youth center and the Direction de la Protection de la Jeunesse, which is a youth protection service, for a period of about 1 year. The anticipated rehabilitation of her son did not materialize, and therefore, in 2009, his mother left Quebec to settle in Winnipeg with a brother of Mr. Ignace. Mr. Chair, as you know that Canada is one of the world's greatest place to live, and we welcome immigrants from all around the world. On the same note, I would like to remind here that safety of our citizens, our society, and its members stays at the top priority in our justice system. Mr. Ignace was convicted in February 2013 of an offense of harassment under Part 8 of Criminal Code. This offense is punishable by a maximum term of 10 years in imprisonment. And I would like to mention here that in paragraph 36, section 1, subsection A of the Immigration and Refugee Protection Act states that a permanent resident who has been convicted in Canada of an offense under the Criminal Code that is punishable by a maximum term of imprisonment of at least 10 years is inadmissible to Canada. Mr. Chair, you will also learn today that this is not the first time Mr. Ignace is committing a crime. The evidence will show that he has a continuous record of committing crimes, including but not limited to robbery, breach of conditions, possession of a woman for dangerous purpose, forcible confinement, assault with a weapon, disguise with intent, theft, and breach of recognizance. Therefore, Mr. Chair, I and my co-counsel, Ms. Nan Cheng, together on behalf of the Minister of Public Safety and Emergency Preparedness, ask the Honorable Tribunal to dismiss the appeal of Mr. Ignace to the removal order and let him settle to his home country where his father and brother has moved. That's all for now, Mr. Chair. Thank you.
So the counsel for the appellant may call your first witness.
Thank you, Mr. Chair. We call our client, Mr. Mitchell.
In the first seat. Oh. So do you swear, tell the truth, only truth?
Thank you. So, do you understand why you're here today?
Yes, I do.
And how important is it to you that you're granted privilege to stay here in Canada?
It's very important to me, and I'm going to try to prove why it is worthwhile for me to live here.
Okay. So, in 2011, you started to attend and complete successfully several learning programs. Is that correct?
Yes.
And they basically carried through to 2014, 2015, and that's where you took the classes related to some training, some employment, and there was even a domestic violence prevention. Is that correct?
Yes.
So why did you take these courses?
Well, I was looking to better myself, to help to improve my skills. I had also been in a relationship with a woman that was older than me, and we often became volatile due to my lack of maturity to handle situations and her ability to manipulate me. So I found taking some of these courses will be helpful to me.
Okay. What I would like to do at this time, Master Chair, is I'd like to submit for evidence A1, A2, A3, and A4. This is for opposing counsel. These are certificates of completion that my client did to show that he successfully completed all these courses. So in 2013, this is when you were charged with this harassment offense in the situation that you just mentioned with this woman.
Yes.
Now, this woman that you were in the relationship with, did she withdraw that complaint?
Yes, she did.
And was there any further police dealings or arrests or issues, any problems at all in the 2 years following the time that you were in the relationship with this woman? You had no other further problems?
No, there was not.
Now, a large part of the counsel for the minister in their case, and as he continuously spoke about in his opening statements, was that these other crimes that he was referring to. Was this the first time you were charged as an adult?
Yes.
And again, the complaint was withdrawn.
Yes.
So, did you have issues with the law while you were a youth?
Yes, I did.
And again, you came to Canada when you were a young child from Congo, correct?
Yes.
When you were 15 years old, you started doing what you would consider petty crimes like stealing.
Yes.
Why did you do this?
Well, we came to Canada the first year I was here. My parents' marriage split up. I was sometimes with my mom and sometimes with my dad. We didn't have much money, and I was hanging out with some sort of not so good friends. And I started stealing money and getting into trouble. I'm not very proud of myself, but I had to do this to get by.
So if you were in Congo, what did many people do if they did not have enough money?
Steal.
And did you spend time in a juvenile detention center when this happened?
Yes.
What did you learn from that experience in juvenile detention?
When I knew I had disgraced myself and my family.
And then did you reoffend after that?
Yes.
How old were you?
16 years old.
So what did you learn from that experience?
I learned that violence and crime is unacceptable, and I'm taking a big risk if I'm ever convicted as an adult.
Okay. So your crimes you committed as a young offender were for basically economic reasons. You needed money to survive.
Yes.
Did your mom have a very active role in your upbringing here in Canada?
No. After the separation, she left and moved to Winnipeg, and my brother and I were basically left to raise ourselves. We might see her once in a year.
And what about your father? Did he have an active role in your upbringing?
He tried. He did his best. But He met our stepmom and they had 2 more children and he had a family with them. But he was always there if we needed him.
Okay. You have some health issues right now that requires you to stay here in Canada.
Yes, I had a surgery and they removed the mass from my back.
Okay. Do we have any documentation on that? I don't think we do at this time. We would like to submit that we would like to get documentation. It has been in the past. But at this time, we would like to just note that we do have doctors' documentation that we can provide for you.
Okay.
Are you required any follow-up treatment for this surgery?
Yes, they need to monitor to make sure it doesn't grow back.
Okay. Are you concerned about your personal safety and welfare if you go back to Congo?
Yes, I am.
Why is that?
Well, in Congo, there is a lot of unsettlement right now. The community that my family is from is the northern part of Congo, where there is a lot of violence and protesting. There is also severe lack of food, shelter, water, and amenities, and I'm very scared to go back.
If you were granted to stay here in Canada, what would you plan to do to show you are worthy of this privilege?
I would apply the skills and tools I have learned in the courses I have taken. I will work hard to get full-time employment.
Okay, great. I appreciate you answering these questions. At this time, Mr. Chairman, I have no further questions.
Does counsel for the minister have any questions at all?
Yes, we do. Thank you, Mr. Chair. You stated in your testimony on February 2013 harassment charge, which was between you and your girlfriend at that time, that she withdrew the complaint. Is that correct?
Yes.
However, you were still convicted of the harassment charges based on the evidence of the telephone calls and messages. In fact, the investigation report states, in particular, the appellant sent the victim a text message, "I hope you die, you dirty whore."
Objection. The counsel is basically testifying. He has to be asking a question. He's not
Okay, counsel, just ask a question.
My question was, were you still convicted of the harassment charges based on the evidence of the telephone calls and messages?
Yes, but
That's fine, you already answered my question. Also, you stated that you were in a relationship with a much older woman.
yes.
What was the age of both of you?
She was 26 and I was 19.
So just 7 years?
Well, yes, 7 years is a big difference. She knew how to,
No, that's fine, you answered my question. You stated that you, while being a teenager, had to steal to survive, is that correct?
well, yeah, but
You have a brother, correct?
yes,
Has he had any dealings with the law?
no,
So he didn't have to steal to survive.
well, no, but
So you stated you started your criminal career at the age of 15.
Objection, Master Chair. The appellant, the counsel of the appellant, he keeps misleading that as a young offender's crimes, they cannot be used to establish that in adult court, as he now is, he only has 1 misdemeanor harassment charge. He took a plea on that, so all his young offenders, they can't keep being brought up that this is when he started his life of crime. He has to refer to that he has had only one. We have to establish that he's had 1 charge as an adult. Those are the only crimes that we can be referring to. Those are the only ones that refer to this appeal.
Okay, the counsel for the minister, just read that directive question, and also the statement you made here will be stricken out from the record.
Thank you, Chair. You began breaking the law at the age of 15, correct?
yes,
And you feel you had to do this?
well, yes, I guess so.
You testified that they were for economic purposes or petty crimes, is that correct?
Yes,
In 2010, you were 17, and you pleaded guilty with 3 friends to robbing a jewelry store. You were convicted of possession of a weapon for dangerous purpose, forcible confinement, assault with a weapon, disguise with intent, robbery, and breach of conditions. Is that correct?
yes.
Do you consider these economic crimes are violent?
I'm not sure, but I guess,
You testified that you have taken several learning courses and the domestic abuse course. Did you take them voluntarily or were they court ordered?
some were court ordered and some I took on my own.
In January 2015, a member of the IRB issued a deportation order and you stated that you understood that your criminality was serious and you knew that you risked being deported. Is that correct?
Yes.
But despite that, you went and reoffended with another crime in December 2016.
That's an objection. So those charges are still pending, therefore innocence is still to be presumed at this point, so they cannot be brought up in this court.
Okay, counsel for the minister, just redirect your question, and again, your statement here will be stricken out from the record.
When you were arrested for this pending charge from December 2016 of conspiracy to commit fraud in a bank branch, your response on the record was, you were just there at the wrong time with the wrong people. Is that correct?
Yes.
You don't seem to be very remorseful for the crimes that you have committed, are you?
Yes, I am.
What is the longest you have held a full-time employment while being adult in Canada?
I'm not sure, but about a year.
In 2016, you claimed you made $8,000. Is that correct?
Yes.
How do you intend to support yourself on that month's money per year?
Well, I've been on social assistance and my brother was helping me. But I'm seeking active employment.
In the past, when you needed money, you would resort back to crime. How do we know that you won't reoffend to do this again?
I would, and I want to stay.
You were required to do 136 hours of community service to pay off some debt of various municipal offenses you committed. Did you complete those hours?
Yes, I think, or almost all of them. I
Let me
think.
tell you, you did 131 hours. You were required by law to do the full amount. Why didn't you finish it?
I don't know.
Both your brother and your dad are gone back to Congo, is that correct?
Yes.
The medical condition you have, how often are you required to see a doctor to monitor it?
I'm not sure.
Do you have any documentation that you can provide that shows it has to be a Canadian doctor has to monitor it?
No.
When was the last time you visited Congo?
In 2002, when we left and came to Canada.
So you have no idea what your community, where your family lives, like as far as the danger wise.
Yes, I guess so.
And both your brother and father live there and they are fine.
Yes, I guess so.
No further question, Mr. Chair.
So, does the counsel for the appellant wish to redirect?
Yes, thank you. I have a few questions.
It is perfect, proceed.
You were asked by counsel for the minister about a lot of past mistakes when you had broken the law. And this was this when you were a young offender? You have, the only charge you have as an adult is the harassment charge, which again was the complaint dropped.
Yes.
In your cross-examination again, you were asked about the courses you took that you were volunteered for or court ordered. Did you complete them all successfully and obtain skills you feel and help you cope and will help you with a productive life here in Canada?
Yes.
I have no further questions at this time.
Okay, witness excused. The counsel for the appellant may call your next witness.
Thank you. I'd like to call my client's father. He doesn't look anything like my co-counsel. Just want to point that out.
Do you swear?
Yes,
Tell
I
the
do.
truth, only the truth?
Yes, I do.
Thank you for joining us today. Sir, your sons came with you to Canada in 2002 when you were here on a work visa with your wife. Is that correct?
Yes.
And about a year later, you and your wife separated and divorced. Is that correct?
Unfortunately, yes.
Okay. Did you raise your sons or did your wife?
Some of them, it happened that at the beginning we shared custody, but after 3 to 4 years, my ex-wife moved to Winnipeg, and it was just me.
Okay. Do you feel that your son maybe found this hard and this might have been attributed to with him getting into trouble as a young offender?
Yes, I think it didn't help. Money was tight because we had to move around a bit and rely just on my income.
Okay. So I have a very important question, and it's, do you feel your son is dangerous?
No, not at all.
I have no further questions at this time.
Does the counsel for the minister have any questions?
Yes, Mr. Chair.
Proceed.
Thank you. You stated in your testimony that you think your divorce from your wife and her leaving from Quebec attributed your son's stream of breaking the law. Is that correct?
Yes, I think it did.
You have another son. Has he ever had any dealings with the law or criminal charges?
No, at all.
So living in the same circumstances, why would you say that it affected one son, not the other?
Well, I'm not sure. It just happened, you know.
You also testified that you don't think your son is dangerous. However, he has been charged with dangerous crimes. How do you justify that?
Well, I just know my son, and he has worked hard to better himself.
You are no longer living in Canada. You have returned to Congo, correct?
Yes.
And you feel safe enough to live there with the rest of your family?
Yes, but I mean, there are dangerous situations now and then, but yes, I feel relatively safe there.
That's all, Mr. Chair. No other question.
Does the counsel for the appellant want to redirect that?
I have no questions for redirect.
So witness is excused. So the counsel for the appellant will call your next witness.
I would like to call my client's brother.
Do you swear to tell the truth, only the truth?
Yes, I swear.
Proceed.
Thank you. Thank you for coming today. You came here with your brother and your family to live in Canada in 2002. Is that correct?
Yes,
So you've supported your brother throughout the years, and even now you even want to help him stay here in Canada. Is that correct?
yes, very much.
Okay. So, in fact, you've even provided his bail money because you put such trust that you know that he will appear here in court.
Yes,
You've returned to Congo, is that correct?
yes. I had an opportunity to return with my father and stepmother, so I have.
But you don't feel it's a good option for your brother to return to Congo and live?
No, I don't. Actually, having been there now myself for a short time, I'm concerned he would experience extreme cultural shock and fall into possible delinquency. He has only really known Canadian life. He was young when my parents brought him here, and he went through a lot when they divorced. And then my mother basically left us. He's working hard to improve himself.
Thank you. I have no further questions.
So the counsel for the minister have any questions?
Yes, Mr. Chair.
Yeah,
Thank you.
Proceed.
You stated that your brother had several criminal charges while living here in Canada. He hasn't held a job and living assistance. He attended court order training programs.
Yeah.
Oh, I'm
Yeah.
Just carry on.
You and your brother lived here in the same house, same environment, correct?
Yes.
Have you ever been charged with a criminal offense or ever arrested?
No.
While in Canada, did you maintain full-time employment for the majority of your adult life?
Yes.
Why do you feel that your lifestyle and your brother's choice of lifestyle were so much different?
Actually, I'm not sure.
You testified that you have put up the bail money for your brother, $2,000 bail release, correct?
Yes.
So, if he is convicted of the charges from 2016, you realize that you will automatically lose that $2,000 because it proves he violated the first condition of the release.
Yes.
Do you not think your brother has a better chance of succeeding in Congo where you and your father are there to support him rather than here?
Actually, we will support him wherever he is.
Do you feel your brother is dangerous?
No.
Even though he has committed crimes that are considered violent?
Yes.
That's all, Mr. Chair. I have no more questions.
Does the counsel for the appellant has any questions to read with area?
I do. You were asked if you thought your brother was dangerous, even based on his crimes, which again, I want to point out are young, when he was a young offender. You love your brother, as you pointed out, but if you thought he was a danger to anyone, would you have posted his bail to allow him to be free if you thought he was a danger to any Canadians?
Absolutely not.
Thank you, I have no further questions.
Okay, does the appellant have any more witness?
We have no further witnesses at this time, we rest our case.
Thank you. Does the counsel for the minister have any witness to call?
No, no, Mr. Chair, thank you.
Okay. Both the appellant and the respondent team have now rested their cases. The counsel will now present their final arguments. Are you ready, the counsel for the appellant?
I am,
Yeah, please proceed.
thank you. So today we have heard many facts about my client's life. He came to Canada when he was young from his home country of Congo, and with his father and his mother and his older brother. Shortly after coming here, his parents divorced. He lived between homes of his mother and his father. He didn't have stability of one constant family home life. His mother didn't provide a constant and secure relationship for him. He fell into a life of petty crime when he was a teenager, mixing with youths when he was 15, 16, 17, and because of his unstable life, all it did was deter him from having that healthy life that most Canadians want. The counsel for the minister has tried to refer to my client's life of crime when the majority of it was when he was a youth. Didn't have the maturity to understand the crimes he was committing. He felt was a necessity of the economics to survive. He got involved with a group of teenagers that were a bad influence, which only added to his downward spiral. And then later, when he and an older woman that manipulated his lack of maturity provoked him into a volatile relationship that brought on consequences, legal consequences. He does admit that he is aware that he has done wrong, and by doing so, he has put his right to live in Canada in jeopardy. However, he has taken steps to change, and he is very remorseful for this. He has successfully completed several courses for personal betterment, as we showed in our evidence, A1, A2, A3, and A4. He diligently worked hard to obtain full-time work, although he has had some health issues he has had to work through. And again, this is another reason it's important for him to continue his residency here in Canada. He is very proud of his brother's accomplishments, and he uses him as a mentor and wishes to improve his life and live the life his brother has had, working hard, crime-free, and supporting himself. He only really knows life here in Canada and is worried the constant duress and political unsettlement that is happening in the northeastern area of his community of Congo that my client's family lives in. He does not feel safe to go back there. He feels he will not know how to adapt and will suffer hardship or worse. He also does not feel he will have the medical treatment he requires to do so of his surgery, and he has had to need that he's going to need monitoring on. I found case law supporting my client. It's Newman versus Canada, Public Safety and Emergency Preparedness, 2007, which I'll give you both a copy. My friend, counsel.
Thank you.
In this case, the appellant, Mr. Colin Anthony Newman, came to Canada from Jamaica, became a permanent resident. He did get into crime, and he was issued an order of deportment for committing a criminal offense. He was granted a stay of 3 years. He later then breached the conditions of the stay by reoffending, and the order was established. Same as today, he appealed the decision on the basis of humanitarian and compassionate relief. Also the same, he had some illnesses, and he was worried about the duress back in his home country. Based on the rivet factors, the appeal was granted under factor F, the degree of hardship that would be caused to the appellant by the appellant's return to his or her country of nationality. This case is similar to my client's again. My client only really knows the life of Canada, and with the unrest he will suffer a culture shock and suffer possible hardship and issues with his medical condition and political suffering or torture if he speaks out or worse. We ask the tribunal's compassion in appealing this decision. Thank you for your time today.
Thank you. So the counsel for the minister may proceed with your final arguments.
Mr. Chair, as always stated, we as counsel for the minister can conclude with the following closing statement. The appellant thus shows strong evidence of reoffending. It is clear that the appellant's idleness, his low income, and his numerous criminal associates do not help his rehabilitation. He himself does not seem to have been rehabilitated at all, and he has expressed little remorse. Through the correctional systems and youth protection, Canada has made a strong effort to help the appellant get back to the right track, such as training, jobs, and housing paid by the juvenile center, and so on, but all without success. The appellant receives considerable help from his family, but he does not help himself. The guidance is not effective. The appellant filed income tax return in his life only once. He is clearly unable to respect strict conditions. He has repeatedly shown his disregard for conditions by reoffending, despite the deportation order issued against him. The appellant does not work and ignore all the help that has been offered to him. He has not established any willingness to comply with the conditions. As a matter of fact, the health condition of the appellant is good enough. Nothing indicates that the appellant needs to receive frequent monitoring, which could not be obtained in his home country, Congo, and no particular difficulty for the appellant to live in Congo. So there is no sufficient humanitarian and compassionate considerations. Here, I also have a case law. Here, I need to supplement it to Mr. Chair. Copy of you. And the counsel for the appellant. In the case law, Roy versus Canada Citizenship and Immigration 2005, yes, your copy. There are many similarities in these two cases too. In that case, the appellant named Marlon Ricardo Raw, who also came to Canada when he was young at the age of 10. He has a lengthy criminal record consisting of 15 convictions. Raw's prospects for rehabilitation are very poor as well. The appellant poses a risk to Canadian society, and his removal from Canada would be consistent with the need to protect our Canadian public safety. And the appellant's immediate family in Canada consists of mother, stepfather, and 4 siblings. And in light of his economic and social circumstances, the appellant is now well established in Canada. Furthermore, no one other than the appellant himself would suffer significant dislocation if he were removed from Canada. So in these two cases, Rubik factors consideration were applied as well. So in the end, given the repeated nature of the crimes, including violent crimes and the appellant's weak establishment, he has not shown the necessary will to take control of his life and prevent reoffending. His removal from Canada would be consistent with the need to protect the safety of Canadian public. That's all. Thank you.
Thank you. So we have heard all the facts presented by both sides. Now it's my turn to provide my decision and also the reasoning behind my decision. Based on all the facts we have found, number one, the appellant has not shown the necessary will to take control of his own life because of the repeated nature of the crimes, including the violent types. And the appellant weak establishment also show in the society. Number two, the appellant has been in Canada for more than 15 years and has received social assistance for that many years. Why he could be work? Instead, he should not work. Number three, he has been involved with criminalized peers for years. That's another trouble point here. Number four, social services has been provided to him for many, many years. However, all those services turn out without any success. Also taking the major risk factors into consideration, such as A, the seriousness of the offenses leading to the removal order, B, the possibility of rehabilitation, C, the length of time spent in Canada and the degree to which the appellant is established here. D, the family in Canada and the dislocation to the family that removal would cause. E, support available to the appellant within the family and within the community. And finally, potential foreign hardship the appellant will face in the likely country of the removal. Overall, on those risk factors, the appellant is not able to show any positive response at all. Having weighed all the risk factors and all the facts presented in this tribunal, a balance of probabilities, I am not satisfied. There are enough humanitarian and compassionate grounds for your stay in Canada. So your appeal dismissed.
Oh.
Tribunal adjourned.